parties present to at that hearing.
But Mr. McKinnon seems to be suggesting, and perhaps he didn't mean to do this, but I just took it this way, but that this would be very helpful to his client if we if this court did order the impaneling or the compliance review panel to be constituted and undertake action here, that perhaps they would find many of these allegations to be well-founded and that a record could be made of that, and this could be very helpful to his client down the line to have this more independent review of this matter made, and could be very beneficial to his client. So what do you think about that?
Well, I don't think he needs that in order to preserve his rights to make the argument or show the presentation to the personnel board. He can bring in whatever evidence he wants that his rights were violated during the course of the investigation, and hopefully would be able to show how those violations impacted the result of the investigation. I mean, that's what I assume that they would try to get to, but that would be for the personnel board to consider. The compliance review board, like I said, Judge, if you ordered one to be convened immediately, it's not going to change that path of his disciplinary action, and the administrative review of that is a totally separate vehicle.
So I guess what you're saying is, while it might be understandable that he would want that separate review by 3 other individuals that we're calling and in fact constitute a compliance review panel, while he might desire that, while it might be beneficial to him in certain ways to have that done, it's not a legal prejudice at this point not to have it done.
Yes, Your Honor, and actually for the record, you're saying that brought one more thing to my mind that I wanted to make sure I put on the record, and that is some of the, because I have read the petition, some of the allegations of violations occurred well before the point where Mr. Gardner was going to be interviewed at the conclusion of the investigation, because as you see from reading the Bill of Rights, that's the last thing that's done in an investigation. The officer's interview is the last thing that's to be done to finish an internal investigation. So it's our position, Judge, that at any point along that line, before December 16th, when there was an attempt made to interview him, he could have filed a request for a compliance review and an allegation that his rights had been violated. And I think arguably, Judge, at that point we would have had to stop and convene such a board to look into that unless we felt like it was cured in some other way. But there was no allegation of violation of Bill of Rights made until, and a request for compliance review until the point where that interview was getting ready to take place. So
do you think that's a waiver?
I do. I do, Judge. I think because of the way the statute is worded, the compliance review is something that occurs during the course of the investigation, not after it's over and done with and disciplinary action has been taken. If that's the point where you are, then you have other remedies to pursue.
All right. Anything else?
No, Your Honor. Thank you.
If I may, Your Honor.
Apparently something.
Sorry.
Sorry, that's okay. If I may, Your Honor, I'd like to just point out why we're here today, and I know that the court knows it, but just so that it's on the record, this is a quote-unquote emergency hearing for a temporary injunction, which we had only 48 hours to prepare for. And I believe Mr. McKinnon even said that this has, and the urgency of it is stressed because of the fact that there's only 10 days to appeal to this Personnel Review Board. And Mr. McKinnon has said that really this has nothing to do with the Personnel Board, but his client's reputation. And if that's the case, Your Honor, and if Your Honor is inclined to entertain that argument, at the end of the day, I really don't see why this couldn't wait for a full and fair hearing on permanent injunction. Because once you order if you were to do that, once you ordered the Compliance Review Board, it'd be ordered. And so, again, if that was even the way...
For a moment. I am of a mind, although I'm not making a ruling at this moment, to dismiss this, to deny the request for this injunction, both temporary and permanent.
And I'm fine with that.
Well, you'll let me finish, because the last part was where I'm going to order you taken into custody, so you may not be no, obviously we're making a little, but the point is, wait until I finish. Sorry. I'm inclined to deny both and dismiss the action. Now, if I do, I want to make it clear that this is without prejudice, obviously, to the petitioner to, at some time in the future, bring this action again. For example, this probably goes without saying, but sometimes things don't in law. He may be reinstated by order of the review board or otherwise, or be rehired or something else, and later find the need to seek this same relief. So obviously it's not precluded from doing that, even if I deny and dismiss this action. But I'm not sure that I'm trying to struggle to find if this is my construction and interpretation of this statute and how it's supposed to operate and how it works in the scheme of things, then there's nothing more to be said with regard to a permanent injunction than there is with a temporary injunction. In other words, it just doesn't, the relief is not available. So I see no reason to keep this case open and prevent, for example, the petitioner here from perhaps seeking appellate review if he decides to do that by just having this thing hanging open. If the petitioner was concerned by language such as that in McQuaid that, we're sorry he did not seek an injunction that sits in McQuaid, well, certainly this petitioner has availed himself of doing that and has sought an injunction, and no one can claim that he's waived or his rights are set on his hands or not sought this remedy. And I think that's fine. Certainly we have ample records of the petition and this hearing. But again, I haven't ruled yet because I want to give Mr. McKinnon a chance to weigh in one more time and have the last word, since he brought on behalf of his client this petition. And I think he should probably have the last word on it. Mr. McKinnon.
Thank you, Your Honor. I'm not going to spend a great deal of time before. I think we sort of, I would call it a beating a dead horse to some degree.
Well, let me interject. I think, I don't want to let you just leave it with that characterization. I've probably beaten the horse 3 times to death, but I appreciate the fact that you've been very patient and tried to educate the court, especially with your client's view of this, your view of it on behalf of your client. So I think you've done that very professionally and very zealously, even though you've been very professional and polite about it. So I didn't want you to think that I feel like you've overdone it. So go ahead.
No, I appreciate it, Your Honor. I think we've pointed out the statute. I think the court's seen the statute. We've discussed all the few cases that are on point. Based on the court's inclination of what I understand, we'd just like to submit, this is just an affidavit, Your Honor, we'd like to submit today, which would be appropriate under the rules of temporary injunctive, just to place in the record. In the event that the court makes its ruling, we can provide that to for the purposes of appeal. So,
sure. Well, here's the thing about that. I'll certainly accept it. And
thank you.
Mark, have the clerk file it. No, court, did you give a copy to?
I don't have another, but I will provide them a copy as soon as we get back.
After all, we are talking about fair process. Right?
Fair
process.
I just have one copy of the affidavit.
Process that's going to be.
But I'll make him another. It's a one-page affidavit attached to the.
How you spell irony, but in any event, yeah, they can get a copy.
Right, I'll provide them a copy. And
now, okay, thank you. I leave it to a reviewing court to decide if this affidavit, since I haven't even read it, is timely and if it has any effect on my ruling or this matter. I think you're supposed to provide affidavits in support of an injunction, temporary injunction at least, before we got here today, and where there's not sufficient notice to start gathering legions of witnesses or counter affidavits, then I certainly think we're supposed to give notice and have it all done by affidavit, which is why we haven't heard any testimony. But be that as it may, I certainly recognize that you should have the right to file this.
Thank you very much.
But I don't think it's going to. Do you think it's going to? I haven't read it again, but you don't think it's going to change?
No, you're right.
If I view the statute as I've said, this affidavit isn't going to change that.
No, Your Honor. The affidavit merely.
It's not an affidavit by, let's say, 5 or 7 members of the U.S. Supreme Court.
I wish I had such an item, Your Honor, but
or 5 of the Florida.
It verifies the pleading, Your Honor, which would have been nothing more than what would have been required had, as we discussed, I think you discussed earlier, had this been without notice. I understand. We brought that for the purposes of providing.
Well, the county did raise that, I believe, in their.
They did, and
motion to whatever it was.
Motion for protective order, and hence that's we provided the court a copy of the to verify the pleadings. Should that be an issue?
Since they have, I think they would say they have prevailed. If I rule as I said, I don't know that they'll really care about this part of it. But there are other grounds that they have raised that I have not even addressed today, and I don't want to suggest by not addressing, not having counsel weigh in on that I have either disregarded them or decided them one way or the other.